I am here in studio with Sam Sutter, a name you recognize because we've used him a number of times to help us analyze legal cases and, of course, on our political nights, too. Sam, former Bristol County DA. He's had experience prosecuting high-profile crimes. You may remember the Aaron Hernandez case. And, of course, you're also the former mayor in Fall River, practicing attorney. Now he's been on both sides of the aisle, so he knows a little bit about defense work and a little bit about prosecution. Actually, I should say a lot about both of those. Now, Dottie Sutter, you're here too because you're a paralegal and you work with him on a lot of these cases, and you've got your own expertise, jury picking, research, strategy, all that good stuff.
Yes, I do.
You should have your own TV show.
Maybe that's coming.
Sure. I mean, that's something we've talked about at times. Just to, even on the radio, it would be fun because I always benefit from her input. She just has tremendous insight into people, which translates into jurors.
Now, you're a very brave man, Sam Sutter, because as I remember when I had you on last week, right before the Karen Reed case came back, when the jury came back, you gave us a prediction as what you thought the verdict would be for the 3 charges. And literally just moments before you walked in the studio, the jury had sent a note to the judge, Beverly Cannoni, asking questions about the 3 charges. So let's review the 3 charges. Then I want you to remind our listeners what your analysis was.
So give me 1 second to wipe the egg off my face because I was wrong. And I have to admit it when I am. I was right that they were going to acquit her of murder too. Mm-hmm. And in my humble opinion, that never should have been charged. Even though I thought Hank Brennan did an excellent job with that analogy when he talked about somebody throwing a boulder off a highway overpass and the boulder striking a car and not intending the person to die, but the person does die. A jury was never going to look at Karen Reed and say she's guilty of murder. So that was a mistake, and wasn't Hank's. It was at the inception of the case when they presented it to a grand jury. The thing is, the district attorney, Mike Morrissey, did have an opportunity to not go forward on murder 2. For some reason, he chose 2. This was after the first trial was a hung jury. So that was a mistake. That one I was right on. Then on the manslaughter, I said that's a close call. I'm not sure what they're going to do on that. But I did say, and I stand by this, Christine, the focus should not have been on manslaughter. The focus should have been on what's called a lesser included offense, meaning there are elements to something within manslaughter that do not rise to manslaughter but still are a crime. Now that's a somewhat complicated concept. It's called a lesser included offense. So here a classic one would be you charge murder 1, murder 2 is a lesser included offense, manslaughter is a lesser included offense, assault and battery is a lesser included offense. It's contained within the murder charge. Here on the manslaughter charge, motor vehicle homicide under the influence of liquor is contained within that manslaughter charge. And on motor vehicle homicide under the influence of liquor, and I gave you the jury instruction, the prosecution would not have needed to prove a collision. Now, I've heard a lot of experts over the course of the Karen Reed saga, which really began last year before the trial. And I've watched court TV a lot, and I've seen other commentators. I haven't heard anybody make that point. But if you think about this, how many times did Alan Jackson, so I think Jackson made some mistakes, but he also did something that was really smart to brilliant. And that was he kept saying in his closing argument, there was no collision. If you watch his closing, I think he said it 20 times. He'd be talking about something, then he'd look at the jury and he'd say, there was no collision. Because he had figured out, and of course he's been living with the case for 3 years, but he'd figured out if they can't prove a collision based upon the approach that the prosecution is taking, the jury has to find her not guilty. If they can't prove that beyond a reasonable doubt. So he said it. Now, if I was Hank Brennan, and once again, Hank's a great lawyer, hindsight is 20/20, but in my opinion, he needed to say as many times as Jackson said there was no collision, he needed to say there doesn't need to have been a collision for motor vehicle homicide under the influence of liquor. She just needs to have caused the death. In fact, if you look at the instruction here, it says...
Pages of it, which I'm looking at.
Yeah, well, it says the defendant's actions cause the death of another person. The defendant caused the death if her actions directly and substantially set in motion the chain of events that produced the death. So If the jury found that she backed up, and she backed up fast, and he tripped and fell as a result of her backing up, in my opinion, that's causation. Clearly, they proved that she drove. They proved that she drove under the influence of liquor. Driving backwards at 24 miles an hour, which they proved beyond any doubt, is negligent. And if he tripped, they didn't, in my opinion, they didn't need to prove the collision. And they had problems with that proof. Because the other one I was wrong about was leaving the scene of personal injury, death resulting. So I wondered whether they had to prove a collision for that, and I went to the library knowing I was coming on WATD, and I did a little research, and they did need to prove a collision for that. But they didn't need to prove a collision for motor vehicle homicide under the influence of liquor, and I think as time goes on, that will be considered the biggest mistake that the prosecution made.
And the only thing they got her on was drunken driving, and what does she get, parole for a year? Was
Well,
that
she
a
gets
probation?
probation. She has to do a program. It is on her record. If she drives again, she faces commitment of 14 days in a rehabilitation program. So it's not a zero, but obviously that's not what they wanted. But I do have some ideas that my wife and I talked about on why the jury made the decision that it did that I haven't heard anybody else talk about. And that is the pressure that the jury must have felt by somewhere, I've seen estimates of 700, 800, even 1,000 Karen Reed supporters outside the courthouse. So it would be impossible for a human being to walk into a courthouse every day over the course of a month or 5 weeks and not see those people and not know that if they convicted of anything other than OUI, that when they left that courthouse, they were going to be screamed and yelled at. And what my wife said to me, and I give her credit for this because she's right on this, she's right on most things like this, but she said, that should have been screened. There should have been a question in jury selection for the jury. Will you be influenced or intimidated by all of the supporters outside the courthouse who are yelling on behalf of Karen Reed? I think that's a legitimate jury selection question. I think Judge Cannoni would have allowed that question. Now, maybe I'm going to learn after I go off the air that, oh, yes, he did ask a question like that, but I didn't hear about that. And Dottie followed the case even more closely than I did.
And you usually work with Sam and are really the key person in helping to pick juries. What's your take on that?
On what we're saying here?
Yes.
I do think that was a very important question because you would look at the juror, who the potential juror that's answering the question, and you can. I would be able to tell because that's what I've been doing for 30 years. I'd be able to tell whether that answer was an honest answer, of whether or not that would influence them, whether or not that would bother them. Don't forget, this day and age, a lot of people now are very concerned what happens after with social media, with Facebook, everything else, finding out who a juror may have been,
right?
Where do they live? Where do they work?
Probably a good idea they impounded the list this time because with the harassment, it's the same for so many things. It's not the event; it's necessarily all the fallout that happens later with people coming after you, etc.
There's no way that wasn't entering their consciousness.
Yes.
Back when I was in my, say, middle years of trying cases, I remember actually somebody that I had a conversation with, a very experienced former trial lawyer, saying, you should always remember this, Sam, juries want to celebrate afterwards. They want to feel really good about their verdict. And that has to be part of your thinking when you're approaching your strategy in your closing argument. That almost inevitable feeling on a juror's part that I did the right thing, I feel good about this, I can talk to my spouse, I can talk to my kids, I can talk to my friends. And I think that maybe Hank Brennan lost that battle to Alan Jackson on the jury feeling good about what it did. So,
2 questions. What's the biggest unanswered question about this trial, and what do you think the strongest evidence was?
Well, I think the biggest unanswered question is, as I look back on it and I zero in on this issue of the collision, I think it's exactly what happened with the taillight. because that was central to the government's case, the way they approached it. They approached it from proving that there was a collision. And I do think there was a lot of uncertainty about exactly what took place with the taillight and the aftermath. So I think that's from an evidence point of view, I think that's the biggest unanswered question. And I'm sure that if D.A. Morrissey could do it again, he would make good and certain that a prosecutor, a senior prosecutor in the office, was sent to that scene immediately, because by anybody's standard, the evidence collection was sloppy. And the defense was able to make it look as if the police were being very unfair to Karen Reed, and that was central to his defense.
Dottie, what do you think the strongest evidence was?
Well, I think if I was trying the case with Sam, I think I would have made a very big deal, especially in the closings, in the opening, of why was she able, once the witnesses were testifying, and two of the witnesses that were with Karen Reed that day, Roberts and McCabe, I believe, went back to the scene, the three of them. There was quite a bit of snow. The snow was coming down. This was all testified. And why was it that Karen Reed was able to tell those two witnesses exactly where the body was, with all that chaos, all that snow, cold, windy, and she right away pointed out and said, "There he is. I think that's where he is." She went right over to the body and found the body.
See, that would have fit with causing the accident and not necessarily a collision, but causing the death, the fall, and then leaving him there.
Now, what about the O'Keefe family? They have already filed a civil case in Plymouth this time, and it's against, I believe, the two bars where the drinking was and Karen Reed. What's the difference? I know that they say the same conduct can either result in civil and criminal liability. What about the burden of proof in civil and criminal?
They only have to prove 50% plus one. They only have to prove a preponderance. So it's a completely different kind of case. And my prediction would be that the bars will settle. So I better be right about this one.
Okay, it's all recorded.
But I don't know exactly what Karen Reed is going to do. Karen Reed stands to make a tremendous amount of money. The Karen Reed story will definitely be a book. It will be a movie. I can only imagine, I was thinking to myself, what kind of advance would Karen Reed get for her book? Karen Reed, what really happened? I mean, I think she's going to get somewhere between $1 million and $2 million. I'll never forget that when Deval Patrick wrote his biography when he was governor, I think the advance that I remember reading that he got, and I love Deval and think he was a superb governor, but I think he got either $1 million or $1.5 million, and that was a while ago. That was like 15.
I'm looking at $5 million. That's what I'm thinking.
Yeah,
for something like
for
that.
an advance. Well, you would know. So really, that much now. Wow. That's
And don't forget, in a civil case, don't forget, you can say quite a bit. A lot can come out in a civil case. You're able to bring out so much more than in a criminal case.
Is that why they're always trying to delay the civil case till after the
And
criminal
there's hardly any
case, like they did
protection.
here?
There's no protection.
It's
Yeah,
true.
so her point, I mean, she's not going to be able to hide behind the Fifth Amendment.
No.
She's going to be deposed. And I can guarantee you she's going to have a very experienced lawyer asking her questions. I've had a lot of experience recently in depositions. It's very different from a trial. I mean, the person you're deposing is like this. They're like 4 feet away from you, and you're looking them in the eyes, and you're asking them really difficult, intrusive questions. So she better get ready for that.
What if new evidence comes to light? Would there ever be any kind of a trial, and would this be considered an unsolved crime?
Well, with respect to the new evidence, we have the double jeopardy clause, and so she is safe as far as being prosecuted again. But unsolved, my wife and I were debating this before we came on the air. I mean, it has to go, she was acquitted. So it has to go into that category, whether or not it's ever pursued, whether or not there's ever any investigation of any others that were there that night, what they might have done. I would say that chances are slim and none. But to me, it has to go into the category of unsolved.
I want to ask you another question, both of you, to think about this, because we're already hearing this from some local prosecutors. The effect that this trial and this case is going to have on picking juries and holding trials in the future here in Plymouth County, in Norfolk County, in Suffolk County. What kind of a ripple effect do you think this is going to have, Sam?
I don't think much,
Really?
because as I look back, and correct me if I'm wrong, I can't think of another case in my lifetime where 1,000 people were standing outside the courthouse every single day during the course of the trial. I think this was a unique situation. You think about the big cases over the last 40 years that we talked about: Big Dan's, William Kennedy Smith, O.J., Hernandez. I mean, just from my own personal experience with Aaron Hernandez, sure, there were, especially initially before all of the evidence came out to the public, he might have had 20, 30 people, but she had hundreds of people. I think that there were parts to this case that are almost unique, and I don't think that we will see that again. Now, the other part of the question is, how about social media pressure on big cases? And yes, that's real. And yes, I'm sure that at judges' conventions, the Supreme Judicial Court, the Appeals Court, they're thinking about that, because that is a very real situation for jurors.
Dottie, you're a keen observer of human behavior. What's your take on this about picking juries?
Well, I have my opinion would be it's all who you pick. So if you pick the right jury, many people will say the jury normally gets it right and the jury normally does the right thing. It really depends. I disagree totally with that.
She disagrees with me.
If you pick the jury that's right for your case, and you think that jury is going to really look at the evidence, but if you could also pick a juror that's going to think of what they see outside, all those people supporting her, what they're feeling, their fears. I think they do overlook some of what really happened on Karen Reed.
Well, it's interesting. It was such a phenomenon here with everything going on. A couple last words, Sam Sutter.
Well, I want to say one thing in response to what Dottie said, and that is that there's this almost cliche in courthouses. Well, you never know with the jury. You can't tell what a jury's going to do. I really think with every one of my over 100 jury trials that when I look back, I've been able to figure out exactly what happened with the jury. And I think the more that I look at this case, I can figure out what happened with the jury. And so I stand by my saying, my axiom, which is that if you have two capable lawyers, based upon the evidence that the jury hears, meaning over 90% of the time, I think they get it right. And as I looked back on this case and I thought about the overcharge of murder, maybe even the overcharge of manslaughter, the lack of focus on the fact that there didn't need to be a collision, the problems with the evidence collection, the problems with the Commonwealth's case, I think even though I do believe they were influenced by all those supporters, I think they got it right.
Well, why do you think it took them 3 days?
Well, now that's a really good point. I was going to forget to say that. Let's remember this too, Christine, for all of your listeners. This was a close case. So that first jury, the hung jury, they deliberated Thursday, Friday, Monday, Tuesday, Wednesday. That's 5 days. The second jury deliberated Friday, Monday, Tuesday, and most of Wednesday. That's a total of 9 days of deliberation before a verdict. And you could tell that there were obviously some people in the room that were for guilty on some of the serious charges. You could tell that by the questions. So, close case, but in view of the problems with the government's case and the fact that I think they overcharged, I think they got it right.
Wow. I always appreciate your commentary. And again, that's Sam Sutter, former Bristol DA, now, of course, doing private practice, has worked on both sides of the aisle here, former mayor of Fall River, too. Dottie Sutter, you're a paralegal. You've worked with Sam on all these cases. You're very good at picking juries. We appreciate your point of view and your commentary. We're going to put this all up online, too. I know we're going to have you back on, too, to talk about something in the near future. I appreciate you joining us.
Thank you, Christine, for having us.
Oh, you're very welcome. I'm Christine James, 95.9 WATD.